Today, I'm very excited to host you for a workshop that will take a slightly different format than usual. The idea is that we're going to be focusing on one very interesting and important insurance law case. Specifically, it's JP Morgan versus Vigilant, which has wended its way through New York courts for a while, but I was most recently decided by the New York Court of Appeals late last year, and I think there's some subsequent history, which I'll defer to the presenters about. And so they are two of the litigators who tried that case, specifically Seth Schafler, who's now counsel at Covington and Burling and represented the plaintiffs. And on the other side was Daniel Sullivan, who is a partner at Holwell, Shuster and Goldberg and represented the defendants, including Vigilant Insurance Co. In terms of format, I'm going to give a very rough sketch of the relevant features of the case, and then I'm going to hand it off to them to add, subtract, or correct me as they deem necessary. And then we're going to open it up to audience questions. This is a complicated case. It's got a lot of different angles. I imagine a securities law workshop could have a separate, entirely different discussion about it, but we're going to focus on the insurance law questions to the best of our ability. So here's my attempt to summarize the relevant factual and procedural history. So back in 2000, when Bear Stearns was still around, it purchased an insurance policy from Vigilant that provided coverage for, quote, wrongful acts, but not for, quote, fines and penalties imposed by law. A few years later, in 2003, the SEC began investigating Bear for certain deceptive practices that privileged some of its customers over others, as I understand it. And the SEC told Bear that it was going to commence a civil action against Bear, and then eventually in 2006, Bear settled with the SEC. As part of the settlement, Bear agreed to pay a $160 million disgorgement payment, along with a separate but related $90 million civil monetary penalty payment. And so this dispute is about the $160 million disgorgement payment. Bear, which, as you all remember, was eventually merged into JP Morgan in 2008 during the financial crisis, argued that this $160 million amount was a covered loss under the policy, and Vigilant disagreed. Vigilant argued that the payment was excluded under the fines or penalties imposed by law exclusion, and also that it was uninsurable as a matter of public policy. So that, I mean, to me, is one of the things that's very interesting about this case. It's a big case, a lot of money at stake, and it ultimately turns perhaps on the question of what is the nature of this payment, and does that render it unenforceable or uninsurable as a matter of public policy and or the relevant provisions of the policy of the insurance policy itself. Procedurally, so Vigilant filed a motion to dismiss on these grounds before the New York Supreme Court and then lost, but then won on appeal before the appellate division. Then the New York Court of Appeals reversed the reversal and so sent it back down to the Supreme Court, where Bear then won its motion for summary judgment, so it went the other way. Then the appellate division reversed again, and it did so in part based on a decision that had come down from the Supreme Court in the interim called Kokesh. And what's as relevant here, Kokesh determined that a, quote, disgorgement payment as part of an SEC investigation was a penalty, at least for the purpose of determining a relevant statute of limitations. And so then it landed in front of the Court of Appeals again, which sided with Bear, or now JP Morgan. And in a written decision, in a decision written by Chief Judge DeFiore, the Court of Appeals decided that the reasonable expectations of an insured, or the insured at the time the policy was purchased, would have been that the exclusion for, quote, penalties imposed by law would not exclude this kind of disgorgement payment. The court's argument was that the disgorgement payment, as a practical matter, and this we can talk more about this, but it was more compensatory than punitive, and so it was properly within the scope of coverage. And so anyway, there's more to it than that. I understand that there's been some procedural history since then, and I'll defer to our experts on that. But so to the question ultimately of, yes coverage or no coverage, the Court of Appeals said yes coverage. But it wasn't an easy case, obviously. It went back and forth a few times, and so hopefully that makes it fun to discuss. So with that, I'll hand it over to Seth and again, feel free to correct me if I got anything wrong.
Thank you very much. Didn't get anything wrong, although there's a lot of detail and a lot of weeds one could get into. I guess the only thing I would add as far as general background is concerned is that this was part of an investigation started by then Governor of New York. What was it back in 2000? Of mutual funds uh, and other parties involved in late trading and market timing in mutual funds. It was a big investigation, involved a lot of different parties. Bear Stearns was just one of them. Um, there were enforcement actions and settlements brought against many different participants in the broker-dealer, mutual fund industry generally. So Bear Stearns was just one of those, and it did settle back in 2005, paying a total of $250 million, of which 90 million was denominated as a penalty, and the other 160 million was called disgorgement. And there's a lot of prior history. I won't go into too much of it, other than to say that this was not the first time the case went up to the New York Court of Appeals. It was previously dismissed by the appellate division early on, where the insurance companies were arguing that because this $160 million piece of the settlement with the SEC was called disgorgement, as a matter of law, it was not covered. And they didn't argue that it was a penalty back then. They argued that it was not covered because disgorgement is the return of ill-gotten gains. And there's an general insurance principle that if all you're doing is giving back money that you were not entitled to get to begin with, and you stole it or you got it through some sort of illegality, you're just returning ill-gotten gains, then you're not entitled to insurance coverage for that either, because it's not really a loss. You haven't really lost something by returning something you were never entitled to, or public policy doesn't allow you to be unjustly enriched. And when that went up to the Court of Appeals previously, we said, no, that's really not the case here, because Bear Stearns was basically a clearing broker. It was not the party that made money. I mean, there was some revenue involved in transaction fees, but basically the bulk of the profits, or all of the profits actually, that were achieved were for these hedge fund who were clients of Bear Stearns, not Bear Stearns itself. All Bear Stearns did is clear the trades, but it was being accused of facilitating the illegality by these other parties, by customers, either by allowing them to make the trades, late trades after the time when the value, the net asset value is supposed to be determined, or what they call market timing, which is a lot of in and out trading to take advantage of, very small, minute changes in the fund values, which some funds did not permit, others did permit. So basically, Bear Stearns said the bulk of what we are returning is not our own profits. And the Court of Appeals agreed with that. And we went back down. There were a lot of other issues, and ultimately we got a judgment in our favor on all issues. And then the United States Supreme Court issued this decision in Kokesh, which was a decision dealing with the statute of limitations. Basically, for enforcement, SEC enforcement actions, there's a statute of limitations of 5 years for fines or penalties, or whatever the exact language is. And the SEC had taken the position that that did not apply because disgorgement was basically an equitable remedy. It wasn't considered to be a penalty as such. And so therefore there shouldn't be a limitations period. And ultimately the Supreme Court in Kokesh determined the other way. They said this is a penalty for purposes of the statute of limitations. And they had a whole analysis of why that was the case. And once that came out, which was in 2017, which was after the judgment had been entered in the case, the insurance companies argued that that judgment required the judgment, that decision of the Supreme Court required the judgment to be vacated because the Supreme Court of the United States determined that it was a penalty. And if it's a penalty, it's not insurable either as a matter of public policy or because there's an exclusion in the policy for penalties. Now, that was not something they had ever raised before. It was something they said for the first time after Kokish came down. But the appellate division agreed, threw the case out. We were able to get the case back up to the Court of Appeals. And for the second time, and what the Court of Appeals decided in 2021 is that the Kokish decision did not determine whether something was a penalty for insurance purposes, that the question of whether something is a penalty for insurance purposes is determined under a different kind of analysis, and therefore we were entitled to get insurance coverage, assuming we were successful on the other issues. As far as subsequent history is concerned, I won't go into that. There were some other issues that had to then be argued in the appellate division in New York, many of which we were successful on, but ultimately the case settled after that, and it's over. So what we're going to focus on today is the issue of penalty. Hold on. Okay. The issue of whether it's a penalty that's insurable as a matter of insurance or whether there's an exclusion that applies. And basically what the Court of Appeals said in its second time at the case in 2021 is you look at this as an insurance case. It's not the same question as whether something under federal law is considered a penalty for purposes of the statute of limitations. Statute of limitations is a different issue. For purposes of insurance, you look at it as a question of contract interpretation. And what are the things that matter when you're interpreting an insurance contract? Well, number one, this is an insurance contract that was entered into in the year 2000, which is practically 2 decades before Kokish was decided. And number two, you have to interpret words in an insurance contract according to common speech and in accordance with the reasonable expectation of the average insured, is the way they put it. And I know that Professor Benton has some questions about that. We can go into that, but that was an important piece of what the Court of Appeals said. They said, when you look at words in an insurance contract, such as the fact that it says you can't insure penalties imposed by law, you look at it from the perspective of common speech, and you look at it from the perspective of the reasonable expectations of the average insured. And you do it as of the time of contracting. So basically, you have to take a look back to 2000. And then finally, there are rules in insurance. I mean, there are rules in general contract interpretation law also, but they have specific application in the insurance context about how one construes ambiguities. So basically, the court says ambiguities generally are construed in favor of coverage, and this is particularly true with respect to exclusions. Now, if any of you have ever spent any time trying to look at an insurance contract, and if you have, I'm sorry for that, I basically have spent a career doing that. They're structured in a certain way. They have provisions that are called coverage grants that kind of lay out what the coverage is. And then there are things called exclusions, which are basically takeaways. And often, sometimes they're in the body of the policy, sometimes they're in add-on endorsements that are specifically negotiated, but they're the takeaways. And basically, the rule in insurance, which is very strongly endorsed in New York, is that when you're talking about exclusions, it's up to the insurance company to make them very clear. And if there are questions about how one interprets them, they should be interpreted narrowly. And here, the question was, this is a policy. It's it's called an errors and omissions policy. Basically, it's like a malpractice policy. We lawyers have malpractice policies. I don't know if law professors, have to get malpractice policies. I don't think so, because if you get it wrong, it's fine. But, if we
Exactly.
did something wrong, somebody can sue us, and therefore you need, malpractice insurance. That's called errors and omissions, or professional liability insurance. Okay, so this is a professional liability policy that covers broker dealers. And so it's specifically provided coverage for governmental investigations. And the primary regulator of a broker-dealer is the SEC. So, the expectation from the beginning is this would cover the sort of thing that would result from a governmental investigation. But there's a carve-out, okay? It covers loss. Loss specifically includes governmental investigations, but it says not including fines or penalties imposed by law. So technically, what that is not an exclusion per se. What it is part of the definition of loss. So if you want to get very technical, this was not an exclusion, it's part of the definition of coverage. The definition of coverage does not include fines or penalties imposed by law. But the court said in a 6-1 decision that when you're talking about limitations, that limiting language in the coverage grant that function as exclusions, even though they're not denominated as such, they're basically treated the same way as exclusions. And I thought that was a very important piece of this for us, because the court looked at this from the vantage point of the burden is on the insurance companies. The burden is not on us to show that it encompasses, this particular type of thing, and it's not covered. So as I went over it and I was trying to think of what I would say to you folks here today, there are a number of things that, in my opinion, influenced the court to come out the way that it did. Number one, the court said you interpret the policy according to the way an average insured would view it. And they said that, generally speaking, someone would distinguish between a penalty and a compensatory remedy. What's the difference between a compensatory remedy and a penalty? Basically, what the court said is that a penalty is not calculated in a way that is based upon the amount or the quantum of injury to the injured party. What a compensatory remedy does is determines what is the scope of the injury, and it creates a remedy that is designed to fit that injury. A penalty, on the other hand, is designed to be unrelated to that. It's designed to say about unrelated to or disproportionate to whatever that actual injury is. I'm going to punish you on top. I'm going to hit you over the head in a way that is not measured by the actual harm that results. You can have no harm, and you can have a punitive remedy. So the court here, and I won't get into exactly what the case relied upon, but for example, the court cited the analogy of liquidated damages in a contract. If liquidated damages for, let's say, a construction contract, says, okay, if you don't do, X and Y by a certain date, you get liquidated damages. That is considered to be a penalty if it bears no reasonable relation to the amount of the harm. So what the court here said is, if the amount of the disgorgement was calculated in a way that was based upon some measure of the harm, then it sounds more like a compensatory remedy. If it's unrelated to or disproportionate to the amount of the harm, that's more like a penalty. So number one, the court said the average person would view a compensatory remedy as being different than a penalty. Number two, what the court said is that sometimes you may have a remedy that has two different purposes. And we relied upon a case called the Zurich case that specifically dealt with this. We called it a dual purpose remedy. And what the court said is if there's a dual purpose remedy, in part compensatory and in part not compensatory, that should be insurable. It's only where a remedy is entirely punitive that it should be uninsurable. And I think that's the right decision, because the purpose of insurance is not simply to indemnify the insured, but to provide funds available for injured parties. So if it has a compensatory purpose, even in part, it's not purely punitive. The reason, for example, punitive damages are not insurable is because the person has already been compensated, fully compensated. This is just penalty. But if it's mixed, it should be insurable. The third thing is that the settlement itself with the SEC very clearly differentiated between what was the penalty piece of it, which they called a penalty, and the disgorgement piece. And what they said is, number one, there was history of how it was negotiated. And this was an important piece of fact that we put into the record, that there was some history of how it was negotiated. The way it went down was that there was some back and forth, and the SEC requested that Bear Stearns provide a measure of the customer gains, which is basically the flip side of the investor harm. And they said, how do you measure that? They had a measure that was quite a bit larger than Bear Stearns, but Bear Stearns came up with a measurement that said it was $140 million. And so ultimately the SEC accepted that. And then they put on top of that a $20 million figure that they calculated as an estimation of Bear Stearns' revenues. So the $160 million was not plucked out of the air, nor was it just purely a back and forth negotiation. It was actually a calculation that was done in a way that one could say the $140 million was intended to be the amount that is attributable to customer gains. The $20 million on top is what Bear Stearns got for its own revenues for clearing these transactions. That's the $160 million. By the way, we didn't seek insurance coverage. Bear Stearns did not seek insurance coverage either for the penalty, the $90 million civil penalty, or the $20 million revenue loss, although arguably we might have been able to, at least for some piece of that. We said we just want the $140 million. And the court was persuaded that that was actually a fact that was established, so that one could say that the $140 million was in fact a calculation of customer gains. So what does that mean? If it's a calculation of customer gains, then it's measured by the harm to the investors. If it's measured by the harm to the investors, then it's compensatory in nature. Whether you call it compensatory damages or not, it's compensatory in nature. And also a number of other things. The agreement with the SEC said you can't get a tax benefit for the civil penalty, but you can for the disgorgement. You can't use you can't get an offset for the $90 million in the civil penalty, but you can for the disgorgement. And actually, that's what happened, because there were these parallel civil actions that were pending at the same time, which ultimately were settled for $14 million, which would have cost a lot more to settle, but because the money paid as disgorgement could be allocated to compensation of these investors, they were able to get the benefit of that. Bear Stearns got the benefit of that, and therefore only had to pay an additional $14 million to settle. So it was actually treated in actual practical fact as being a compensatory remedy for purposes of dealing with the civil plaintiffs. So when you take all these things together, the majority of the court said this has the earmarks of a compensatory remedy. It certainly is not solely punitive. And one more thing that I think is important to kind of note here, and that is that the insurance companies never raised this issue at all until after Kokish was decided. One would think that if this was obviously a penalty, like the dissent seemed to think, because the law was clear that this is, a penalty, disgorgement is intended to deter, it's nothing but a penalty, that's what the insurance companies would have said from the very beginning. In fact, they did not. They first raised this only after Kokish came down, which is, 20 years after the policy. So, that is actually something I think was influential to the court as well. So ultimately what they did is they, I think, properly looked at it as an insurance question, as a carve out from coverage that preserves the compensatory purpose of insurance and only takes away from coverage if it's clear that it's not supposed to be coverage. Insurance company can always say, hey, this is disgorgement. I put an exclusion in the policy that says no coverage for disgorgement, but they didn't do that. They tried to argue a penalty exclusion, and there was a specific penalty in the SEC settlement that was not this disgorgement piece. So, putting all that together, it was 6-1, and we had a lengthy dissent there, but I think the court kind of looked at it the right way, and the rest is history.
Great. Well, thanks, Seth. So, Daniel.
Sure. Well, thank you, Travis, for having us both, and hello to all of you. Also, give a warm hello to Seth for being here. It's not often in our line of work that you get the chance after a case is over to have a sustained intellectual discussion with a former adversary about the really interesting parts of a really interesting case. So this is a real treat. Can everybody hear me okay? Let me just check that. Good. Okay. So I've got I think the harder task here, at least at the beginning, because I have to argue the counterfactual world of what if the court had agreed with us and what were the arguments that we were actually making. And of course, the court ultimately went the other way, and Seth, I think, nicely laid out the steps in the reasoning that the court took and why the court reached the decision that it did. So I'm going to try my best to kind of lay out the world as we saw it, the argument that we made, and then I think maybe try to point out for discussion purposes what are some of the, to me at least, and this is not at all intended to be exhaustive, what are some of the really interesting fault lines in the case and in the decision. And as Seth said, this is just a sampling. This was a very lengthy case. It had many subplots and many twists, and we're just going to cover a little bit of them here. I myself only got involved, I'm a relative newbie to the case. I got involved, I think, 15 or 16 or so, after the trial court had ruled in favor of Bear Stearns at the summary judgment stage, and then I came in on the appeal. Some of my colleagues to the first department. And then we went up to the Court of Appeals and so on and so forth. So with that introduction, so we in our argument on the coverage for the $140 million essentially was in two parts. And the first was that the $140 million disgorgement, or $140 million portion of the disgorgement payment for which Bear was seeking coverage was not insured under the contract because it was a penalty imposed by law. And I'll stop there for a second and say that there was an issue in the case about, well, there was an issue in the Court of Appeals opinion about whether or not it was an exclusion. It wasn't really litigated by the parties. The Court of Appeals just sort of went there and said, we're going to treat this as an exclusion. It is important in insurance law whether something is part of the insuring agreement or the exclusion. The exclusions are separately laid out in the policy. The grounds we were relying upon were in the insuring agreement. And of course, something can be put negatively or positively. So I think it's hard to say that, well, because you have a definition that says it's going to cover different types of damages, either as a settlement or a judgment or costs, expenses, ancillary to the settlement or the judgment, but all types of damages, but not penalties and fines or penalties imposed by law, to say that because the second part of that is negative, therefore it acts as an exclusion when two sophisticated parties have a established way to list exclusions. It's called the exclusion section of the insurance policy. Struck me as unnecessarily insured friendly, but that's what the court, that's the way that the court went. Another point that made it sort of particularly ironic here is that fines or specifically penalties imposed by law, which is what we were relying upon, is the flip side of damages, right? So the way that when you looked at both New York and federal law defining what damages are and what a penalty is, they're essentially mirror images of one another, right? As Seth said, damages outside of special cases like punitive damages or treble damages or something like that, compensatory damages are measured by the harm to the injured party and are designed to compensate that party for the monetary equivalent of the harm suffered. A penalty is an assessment for an infraction of a public law, usually imposed by the government, but not necessarily imposed by the government. And many of the hard cases in New York law are situations where a private party was invoking the power to impose a punitive assessment on a defendant. But a penalty is an assessment for an infraction of the public laws designed to deter the misconduct by the wrongdoer and by others, right? It has a specific deterrence purpose and an illustrative purpose. So those are mirror images of one another. And they both came up in the insuring agreement. So we said, this is a penalty imposed by law because that's the nature of disgorgement. The second argument we made on this issue was that New York public policy precludes insurance coverage for punitive assessments. There's a sense in which we were arguing for an extension here because it had been only applied to punitive damages in the past. And we were saying, well, these aren't punitive damages in the traditional sense of the term, but they are imposed for the same purpose, to deter, and the same rationale to protect the deterrent effect of punitive damages from being essentially vaporized by the insured's ability to put the costs onto its insurer, apply to a punitive assessment like a government penalty that we had here. So we had a contractual ground and we had a public policy ground. You know, if you look at the Court of Appeals decisions, one of the interesting things about it, I think, is that those two grounds are conflated a little bit. The court really focuses on the contract, I think. That's where it begins, and that's really where the analysis goes. It doesn't sort of really separately analyze the public policy ground, although it was certainly aware of it and understood itself to have been disposing of it. But it invoked this Zurich case, which Seth talked about, to determine whether or not the SEC disgorgement payment counted as a penalty or not. Zurich was a case for purposes of the contract, but Zurich was a public policy case. Zurich was a case about whether or not New York's public policy against insurance for punitive damages would apply to a Georgia punitive damages award. So it was not a contractual case. It was about the application of the public policy. I'll come back to Zurich in a minute, but that's sort of one example of how I think if you look at the Court of Appeals opinion, it might not be necessarily clear that there were really two distinct grounds that we were arguing, two distinct defenses to coverage, one contractual and one on the public policy. We also had another argument which is related to this that I'll just mention, although I won't go into it, which is as an evidentiary matter, whether Bayer had proven that $140 million actually did reflect its customers' gains as opposed to its own gains. And as Seth pointed out, there was some negotiating history. There was actually no direct evidence or very little direct evidence of that negotiating history. There wasn't anybody from the SEC who testified. Bayer's own in-house lawyers didn't have any recollection or understanding of how the $140 million was calculated. There was just partial testimony from Bayer's outside counsel, of course, about privilege, as it would be appropriate for him to do so, recounting some of the negotiating history. On the other hand, there were also settlements the SEC had reached with Bear Stearns' actual customers, numbering in the hundreds of millions of dollars. And we pointed that out to the court, and that's a point that Justice Rivera picked up in her dissent, but obviously it wasn't enough in the majority. So that was a part of the case. I want to get into, well, just before I get into a couple of the points that I think are interesting for discussion, I just want to make one or 2 points to sort of set forth what our contractual argument was. So our view was the law sets forth what a penalty is, both for purposes of New York law and, for that matter, for federal law, which are the same. And the distinction is as I laid out, right? Compensatory.
Hey, I'm gonna have to call you back. Sorry.
Is to measure the losses of the injured party to compensate that party for its losses, whereas a penalty is an exaction imposed in order to deter for an infraction of the public laws. There was a long line of New York cases going back to the early 19th century that made that point. When Kokesh came down, then the Supreme Court held that for purposes of the general federal statute of limitations, which says that it's 5 years for a penalty, and applied to SEC disgorgement, the court said, well, that is a penalty. In order to answer that question, the court applied that same or a parallel line of cases in the federal system, defining what a penalty is, imposed for an infraction of the public laws to deter. So we said those are exactly the same principles that have long applied under New York law, and so the court should apply those here. And actually, the Court of Appeals accepted our view of what the definition of a penalty is. The court started out by saying, a penalty is imposed to deter for an infraction of public laws versus compensation, which is imposed to compensate the injured party for its losses. Where I think the difference between us and the Court of Appeals, to put it neutrally, was that in determining what SEC disgorgement is, its nature, the court did a couple of things. One, the court looked at Kokesh and said, well, Kokesh is a later decision. This is the point that Seth made, right? Kokesh came in 2017, I think it was. That's long after the insurance policy here, so we don't have to worry about Kokesh because the parties couldn't have had it in mind when they entered the insurance policy. Our response to that was, wait a minute, what does a court do when it decides a case, right? And this is one of the fault lines I think is really interesting here. And as you guys probably know, there's a healthy debate about this. Do courts, announce the law? Do they find the law? Do they change the law? What do courts do when they issue a decision? And looking at it from the perspective of a practitioner, the answer is it depends. Sometimes courts do change the law. Sometimes courts do find new rights. There are watershed rules of criminal procedure. There are, changes in the law, right? Courts overrule their prior decisions, right? That we all know that can happen. That's not what the Supreme Court did in Kokesh. In Kokesh, the court was saying, well, to answer this question, what is a penalty traditionally and what is SEC disgorgement traditionally? They went back to the first disgorgement case from the 1960s, a case called Texas Gulf Sulphur, to determine what disgorgement is, how it came about, and what its nature is. So we said all the court was doing was applying longstanding law to a problem that simply hadn't been answered yet because the Supreme Court only hears, how many cases a year. So that's, I think, one interesting question is when you're trying to define the meaning or the application of generic legal terms, damages or penalty, in an insurance contract, First of all, how do you define them? Do you define them in an insurance-specific way, which in practice often means in a way that favors the insured? Or do you say, well, what is a penalty in the law? What's the ordinary definition of a penalty? Is that what the reasonable expectation of the insured is? Emphasis on reasonable as opposed to emphasis on the insured's perspective. Our view was you just look at Black's Law Dictionary, it'll tell you what a penalty is, and that's reflected in the case law going back for 200 years. The other aspect of it was what I might call, for lack of a better way of putting it, a functional versus a formal approach, or a functional versus an essential approach. So our view was you have to, and the First Department's view was you have to look at what SEC disgorgement sort of is in its nature, right? It is imposed to deter. It is imposed for an infraction of the public laws. It's designed to make an example of the insured. And from that perspective, it has to be a penalty. The SEC is not entitled to impose damages. When the SEC imposed the award, they didn't say we're imposing this disgorgement award to measure the harm suffered by mutual fund investors as a result of the market timing that Bear Stearns facilitated. They said we're going to make an example of Bear Stearns, which was supposed to be the hub of the market timing world, and we're going to have them give back their ill-gotten gains. And the New York Stock Exchange, which also has sort of parallel investigation and a parallel order, specifically regarded the whole thing as a penalty. The court focused on what the SEC did with the money. So, for example, the money went into the Fair Fund, which is a fund designed to give money to investors harmed by securities law infractions. Sometimes the money is distributed, sometimes it's not. The record was silent on whether or not all of the money was distributed or not. So we said it doesn't make a difference, what they do with the money, whether it was used as an offset, what the tax treatment of it was. The question is, what is it as a substantive matter? And incidentally, the $90 million penalty also went into the Fair Fund, so that was a sort of prove too much point. I'm going to try to wrap up here real quick because I don't want to go on too long. But that's another, I think, cross-cutting point is do you look at it from a functional perspective or from an essentialist perspective? And the last point was Zurich, right? So Seth and his colleagues coined this sort of idea of a dual-purpose remedy, which I think was an ingenious approach. Obviously, it was very successful, but it derived from the public policy context, right? When you're saying, as a public policy matter, we're not, even if you mean to insure this, we're not going to let you insure it. There ought to be a high standard for that, right? Because you're overriding what the contract says. When you're defining what a penalty is under a contract that the parties agreed to, it doesn't clearly follow that the same sort of strict rule should apply. And Zurich wasn't a contractual case; it was a public policy case. Our view was, you just look at what this exaction is. Is it in its primary nature a penalty, or is it primarily to compensate? But the court kind of glosses over that and applies this public policy case to the contractual setting. The last thing I'll say is that just from I was talking about the difference between an essentialist approach and a functional approach. I don't want you to get the impression that our view was kind of pie in the sky. It was also very practical. The whole theory of the case from Bear Stearns' perspective was this $140 million was not our own gains. It was the gains of we were ordered to disgorge the gains of our customers. We didn't even have any net profits. We were just a facilitator. $20 million was sort of our gross gains, and then we had our own costs, and those costs, we didn't make any money from this. Well, if that's true, and if it's true that Bear Stearns was obligated to disgorge $140 million that it never even earned, that were its customers' gains, that means the exaction is even more of a penalty, because it's absolutely the case that Bear was left worse off. And that's a point that the Supreme Court made in Kokash and made again in the Liu case, which came out in the middle of briefing the issue to the Court of Appeals. So, you know, what the SEC essentially said was, you made 20, you know, according to Bear Stearns' theory of the case, you made $20 million doing this. We're going to make you give that back and make you give back 7 times that amount because we want to make an example of you. And our view was, that's got to be a penalty. So in any event, I'll stop now because there's a lot here, and I want to give you guys all a chance to talk. But hopefully that's enough to get the conversation going.
That's great. I mean, and so we've gone a little bit longer than we expected. If would you guys have some time to stay a little bit after the hour, Seth and Daniel?
Yeah.
Okay, because I know we have a few questions. I might just open with a quick one, and hopefully you can find a quick response. So, I mean, one question you get asked when you're teaching this kind of material is like, okay, reasonable you know, these rules of insurance policy interpretation that tend to lean in favor of the policyholder makes sense when you have a small policyholder, but not when it's Bear Stearns, you know? And so like reasonable expectations or narrow interpretation of, I mean, come on, like these sort of formalistic interpretation rules, or even a sort of general, I mean, this was implicit in the majority opinion, I think, like a sort of reticence to rely on public policy reasons to deny coverage, right? That you know, you can use public policy to find it, but you should only ever very rarely use it to not find it. That's going to be taken advantage of by a sneaky party like Bear Stearns, which demonstrably, you know, does shady stuff. And so is when you're litigating a case like this, I imagine that this is the question, do those types of consideration, you know, the nature of the policyholder in a situation like this, like how do you think about that?
I guess what I would say is, in general, first of all, a rule like reasonable expectations is not just supposed to protect some little insured. You know, the insurance industry is a different kind of industry. It's basically charging a premium for taking on a risk, and they are very sophisticated. They know exactly what they're doing. Even when they're dealing with a party like Bear Stearns, they're the ones that set the terms of what they're prepared to insure for an exchange of money, and they should be held to the bargain that they strike. Now, particularly in this case, because if you are a broker-dealer and you're buying an insurance contract that covers you for acts, errors, and omissions in the performance of functions of a broker-dealer, you're buying insurance for governmental investigations expressly. That's what it is. That's what it says. Now, if this insurance policy does not cover disgorgement, which is the primary remedy that the SEC can impose, it doesn't cover injunctive relief because that's not monetary, and it doesn't cover, you know, penalties that are denominated as such. Well, what exactly does this policy cover? You know, so when you are a broker dealer like Bear Stearns, regardless of how sophisticated you are in the financial world, you're still entitled to get what you would reasonably conclude that this policy is supposed to cover, and not, based upon some technical explanation. By the way, it is extremely significant that the SEC itself did not think that it was imposing a penalty. And it specifically said you can't get insurance for the punitive damages, but it didn't say that about the disgorgement.
Great.
They thought they were compensating. They did.
Dan, you want to?
Sure. Sure. Well, I'll say 2 things. One is, as a practical matter, in insurance cases, I have to say, sometimes the fact that you're dealing with a well-heeled, sophisticated insured makes a difference to the court's willingness to impose what is generally, in terms of the rules of construction, a pro-insured slant, but not that much. By and large, courts, they interpret, they resolve ambiguities in favor of the insured. They tend to read exclusions narrowly. They tend to read, the coverage grant broadly. So just from a purely like, what's it like out there? Insurers, I think, make the argument, and sometimes it resonates. If the on your side, you ought to win as an insurer. But courts do generally apply those types of, rules, contra proferentum and the like, whether the insured is, a mom and pop or big shop like Bear Stearns. To thinking about what Seth said, and this is another point that I was going to mention, and it goes to the point about a sophisticated party like Bear Stearns. The fact that the characterization of the amount in the SEC settlement agreement always the answer to that from my perspective always was, well, wait a minute. If you're the SEC, like, it's kind of like the agency and the insured are playing with the insurer's money, right? And there are, if you think about the concepts and the theory behind insurance, right? Like there are all kinds of moral hazards you're trying to watch out for, and while at the same time, making sure that the risk for which you bought protection is actually going to be covered. So, I understand that kind of back and forth. But, when the agency settles with Bear Stearns, they're not worried about the insurer's pocket, right? What they want is to get and this is a question that incidentally Judge Garcia asked at the argument, and he could kind of make the point a lot better than I could, because he's on the bench, and so there was a limit to sort of how pointed I felt I could be about it. But, the SEC wants to get a big number, right? That's what they want. They want to be able to tell everybody that they're cracking down, on the wrongdoers, and look at the large top line number. They're going to tell you about $250 million. They're not going to say $90 million in penalty, $160 million disgorgement. They may say that, but the headline is the big number. And Bear may be willing to pay a bigger number if they can put more of it into an insurable bucket and less of it in an uninsurable bucket. Mm-hmm. It's not as though when the SEC imposes those terms about you're not allowed to recover insurance for this, you tax treatment for that. Those are standard terms. If you look at a lot of the other orders, they've all got that kind of language. So it's sort of a standard approach. And the insureds are repeat players in that market. The insurers, of course, are not, because they're not regulated entities. So there's an aspect to that, as I say, I don't want to use the word collusion, but there's an aspect where the insurer is not in the room when that's being negotiated, and so that's a way that I think sophisticated in insureds, and frankly sophisticated plaintiffs lawyers too, right? If you're a sophisticated plaintiffs lawyer contemplating bringing a tort case against a party, you damn sure you're going to write your complaint in a way that, if you know anything about the way that, say, CGL coverage works, you're going to write it in a way that enhances the possibility that there'll be insurance coverage. Maybe you can plead around it, maybe you can't, but it's going to be on your mind.
Great. So we have a queue building, but I was wondering, there are two questions that were asked in the chat now that are kind of on point here. And so both Tom and Bob Walsh posed a question kind of on this topic. Tom Baker, would you like to jump in, or?
Sure. I mean, it definitely relates to what you were just talking about, which is, what do you guys think about, on a going forward basis, the ability that this gives the prosecutor to craft its demand in the initial instance, or the plaintiff's lawyer for that matter too, and to be in or out of coverage. And and I think that my sense is this is increasingly an SEC strategy that's in part a reaction to the concern, the moral hazard concern raised by the fact that it's all covered by insurance. In other words, this sort of new thing, frankly, is not the SEC trying to, asking for things that are covered by insurance. The new thing is the SEC explicitly demanding settlements be things that it knows, are not covered by insurance. And, so it's it's an interesting lever that they have to exercise. And, plaintiffs lawyers too. I mean, because the plaintiffs are, of course, are putting a percentage of the money in their pocket. They're less likely to demand things that aren't covered by insurance, but they could.
So I guess what I would say is, number one, if the insurance companies, recognize coverage, they could probably be in the room if they wanted to have an influence on how cases get settled. But as Tom said, the lever is actually in the other direction. The SEC, when it wants to increase the impact of the settlement, will say that something is not insurable. Or in this case, they would say you can't get any offset from it in relation to the civil action. You can't get any benefit at all. You could have to pay the same amount twice from settling with the civil plaintiffs and from the settlement with the SEC. But that was exactly our point, is that the SEC, has the power to determine what the nature of the settlement payment is. If they want to say, this amount of the settlement is going to be usable for purposes of settling with the civil plaintiffs, then they can do that. And if they want to say, no, you can't get insurance, they can do that. And by the way, the insurance companies, all they have to say, and they're pretty sophisticated, is my policy doesn't cover disgorgement. It's just real simple. You just write down, this policy is not covering insurance. The problem is, then you can't sell your insurance policy. But what you can't do is say something at the time that you're selling the insurance policy, which is, hey, I'm going to provide coverage for governmental investigations. And then when the claim comes in and says, oh, by the way, nothing that the SEC could impose would be covered.
I think you're on mute, Travis. I see you talking, but I'm not hearing anything.
Yeah, sorry, thank you. So we have several other questions and not much time. So I'm gonna see how many we can get in. Bill Goddard, would you like to ask yours next?
I would love to. Thank you. I've been back and forth with my good friend and co-instructor, John Buchanan, about the case that we dealt with in the insurance litigation class, Level 3 Communications versus Federal Insurance, and its evil twin in the 11th Circuit, CNO Hotels and Resorts versus Twin City Fire, which hold that if anything is restitutionary in nature, and certainly disgorgement, you can make that case, that can't be covered. And of course, Posner cites to no authority, and I don't know to what great extent he has been followed, but I'm just having a hell of a time reconciling this decision with those. Can you help me?
Yes, I can help you. That was the argument that the insurance companies made from the inception of the case that went up to the Court of Appeals in 2013. And what the Court of Appeals said in 2013 is that it may be true, although they didn't actually have to rule on this, it may be true that merely returning your own ill-gotten gains is not insurable, either because as a matter of public policy or contractually, but that's not what this case is about. This case is about paying a requirement that Bear Stearns pay for its customers' gains, which it alleged to have facilitated, but did not obtain the benefits of. Think of it as an officer or director that's covered by a D&O insurance policy, and somebody is and a director is accused of breach of loyalty by enabling somebody else to earn profits, and it could be a negligent breach or a grossly negligent breach. And are you saying that that's an uninsurable? No, you can't be saying that. So we said that principle is simply not applicable here to the extent that the loss is derives from customer gains. And that's what the Court of Appeals said in 2013. Then, after Kokesh came down, the argument changed, because although allegedly this is law from time immemorial and everybody knows what a penalty is, nobody actually argued that this was a penalty until the Court of Appeals decided that it was a penalty for statute of limitations purposes in 2017, at which point it's obvious to everybody that this is a penalty and it's uninsurable, and that's what this latest decision was about.
Thank you very much.
Dan, do you want to
Well, I don't have too much to add. I'm not familiar with two cases that Bill is referring to, but you know, I do know that it can indeed be difficult to square, you know, insurance decisions from one jurisdiction to another. And in fact, one of the interesting things is all the forum fights that happen in the insurance context, where you're trying to get into the right forum because the law is actually different in California versus, you know, New York, Delaware, whatever it is. You know, just well, I mean, I don't want, I can go back and forth with Seth all day, but I'll stop because I know there are a lot of questions, but maybe I'll have my chance to defend the role of lawyers coming up with new arguments to make as a case goes on, and not being limited to the arguments they made at the motion to dismiss stage, which is a novel principle of law. But I'll save it.
All right.
Thank you, Wes.
Casey Corvino.
Yes, thank you so much for coming today. I've really loved this format of how you said having the opportunity for both sides to speak to each other in front of us, and I really hope the good professors do this format again. It's been really awesome. I had a two-part question concerning Kokesh and the court's, for lack of a better term, timeline concerns, and that was as follows. As Kokesh relied on case law that did predate the policy here, wouldn't that case law have regardless informed the parties' understanding of the policy? And further, even if the court did grant certiorari to settle a narrower statute of limitations disagreement among the circuit courts, couldn't that underlying disagreement that was in existence prior, should it have been prior enough that it was at the time of contracting, wouldn't that have regardless informed the party interpretations? I ask because I felt like the court's response to these concerns in the dissent and amidst the parties, it came after and it was decided on a narrow question. It felt to me as if they were sweeping this under the rug more than they were actually dismantling this argument. And I was hopeful you guys can speak to that.
Well, I'll start on that one because that one seems like it's tailor-made for me. But I mean, obviously, I agree with you, Casey. And I mean, I think that that is a flaw in the court's analysis because so a few things, right? It's kind of like the principle that, you know, just because there are two interpretations of a policy term or, you know, any contractual term, it doesn't mean that it's ambiguous, right? There has to be sort of two interpretations of roughly equal plausibility or reasonableness in order for the contract to be deemed ambiguous. Otherwise, you know, you would always have ambiguity in the insurer in the context of insurance. The insurer would always lose. Whenever you have a contra proferentum rule, the drafter would always lose. And that's not what happens. Well, in the same way, just because there's a dispute about what the law is, and the Supreme Court grants certiorari to resolve it, that doesn't mean that the answer was not obtainable before the court ruled, or doesn't mean that the court's decision is a change in the law. As I said, here the court was relying on a lot of very old decisions to reach the conclusion that it did, and you know, the law has an interesting way of developing. Sometimes, you know, once a question is asked, the answer is actually pretty clear. Kokesh was a unanimous decision, and it was only, you know, I don't know, 5 or 10 pages or something. I mean, it was not a controversial decision at the Supreme Court at all. And so that's the first point. The second point you made, I think, is also an astute one, which is, you know, what are the reasonable expectations of the insured? Well, there was at a minimum uncertainty about whether or not disgorgement would be considered a penalty or not. There was plenty of law, as I said, going back to the 60s, that said that this disgorgement remedy, which was originally recognized by the courts and then was kind of incorporated into statute, was a deterrence-based remedy, and it was designed to punish wrongdoers for infractions. So then I think you come to the question, well, wait a minute, then to Seth's point, well, so what were you buying insurance for then? Hang on a minute. if the SEC can't impose damages and disgorgement is a monetary remedy they can impose, you know, is this essentially illusory coverage, which was an argument that they made? The answer is no, because state attorneys general, in particular the Attorney General of the state of New York, under the Martin Act, are empowered to seek and impose large damages awards for violations of the securities laws. And remember, this policy came out in the year 2000. Well, Elliot Spitzer became the Attorney General of the state of New York in 1998, you know, the sheriff of Wall Street, and he was using the Martin Act to significant effect during his tenure. As I said, the Martin Act specifically allows the Attorney General to seek damages, and that's what the insurance policy covered. So anyway, that's my response to that. But I think that those are both, you know, those are both good points. I'm curious to know what Seth has to say.
Yeah, I have a couple of things to say. Number one, the idea that this policy is not illusory because it covers Martin Act claims, but it doesn't cover anything that is a claim brought by the SEC does not pass the face test. I mean, you know, the primary regulator of a broker dealer is the SEC, and if it doesn't cover anything that the SEC might want to do, then that's not a reasonable interpretation of the policy. As far as the old case law is concerned, I mean, that case law was simply not regarded as being applicable to disgorgement. Disgorgement was viewed as an equitable remedy. That is what the SEC said that it was. That accounts for the way that it used the disgorgement remedy all the years. Eventually, somebody did come up with the argument that it's a penalty, and they won on that. But back in 2000 and back in 2005, it was common ground, almost completely without contradiction, that disgorgement was considered an equitable remedy and not damages. That's the reason why the SEC routinely brought these cases well after the 5-year statute of limitations. And so that was the understanding. That was the actual understanding that the SEC had when it negotiated this settlement with Bear Stearns. Dan talks about essentialist versus functional. I don't know that I would term it that way, although I do agree that their position was essentialist. I mean, it's essentialist because they're saying disgorgement means disgorgement means disgorgement, regardless of what the facts of the case are, regardless of when the settlement was, regardless of what the negotiation history was, that because you can come up with a legal argument that penalty means something in the abstract, that this is a penalty, even though at the time that it was settled by the parties, that's not what it meant. So basically, in my opinion, to apply that would have been to change the settlement agreement between the SEC and Bear Stearns and make it mean something different than it meant before. And the last point I would make is that the Supreme Court of the United States, in a decision called Liu versus SEC, which was decided in 2020, which is 3 years later, actually decided that Kokesh wasn't so clear and that it's not a penalty for all purposes. And they said that it doesn't mean that the SEC doesn't have the power under its equitable jurisdiction to award disgorgement, because equitable jurisdiction does not include the imposition of penalties. And they said no, disgorgement can be an equitable remedy, and you'll see that in the court's decision, and that I think helped us a lot. That even now it's not entirely clear what federal law is on when something is or when something isn't a penalty. And then when you add to that that this is not a question of what federal law is. I once had a professor many years ago. He said when the answer is in the law that something is X, you should ask the question, for purposes of what? Okay, so somebody says, yes, this is a penalty. I say, for purposes of what? Okay, statute of limitations is one thing. An insurance contract is a different animal. Okay, for purposes of insurance, part of the main reason of insurance is to provide compensation for injured parties. If you now say that any time somebody agrees to something and it can be construed as a penalty, there's no insurance, it basically cuts off the insurance vehicle for a lot of things. For example, lost profits are often insurable, even though that puts the insured in a worse position than it was before the event happened. But that's insurable. The insurance companies can say, I don't cover this or that, okay? But if you're now interpreting an insurance contract, that's not governed by whatever the principles are in federal law, which even to this day are not clear on what is or is not a penalty. And if it was so clear back then how come the insurance companies didn't argue it?
We are well over time, and it's a question for the presenters whether you're interested in taking one more question or whether you have to go to dinner.
No, I'm good.
I'm happy to stick around, and I would actually say one thing. I think the points that we're to me get at the heart of what's so interesting about this case, in a number of ways, and I'm going to try to remember them. But I didn't write them down. I was listening, but just as it said, right, in the statutory interpretation context, right, that no statute pursues its purposes, to the end of the earth, but it's limited by the compromises that are embodied in the statutory language. And so you can't say the purpose of the statute is to, compensate injured parties, right? You have to say, if the statute says we will compensate for X, you can't say, well, the purpose is to compensate, so we're going to throw Y in there too. No, the statute says X. So too with a contract, right? Just because an insurance contract in general is designed to provide insurance coverage, it doesn't mean that it covers everything. The question is what did the terms of the contract actually mean? And Seth was saying, well, for purposes of what? Well, when you're using when you're using a general legal term like penalty, it doesn't have a special meaning in the insurance context. If the contract says, the insured shall have the right and duty to defend, the insurer shall have the right and the duty to defend the insured against blah, 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 right? That's duty to defend language. That has a specific insurance law meaning. It's like a term of art, right? That's an insurance law term. But if the contract says, uses a term for causation, right? Damages caused, right? In whole or in part by X. Well, what does causation mean? There's no special insurance law meaning of causation. In fact, the New York Court of Appeals had held exactly that in a case we cited, the Burlington case, in a decision by Judge Fahey, and said, well, we're going to just apply ordinary tort principles of causation to determine what that means. That's what we were saying here. Apply the ordinary understanding of what a penalty is compared to what damages are, right? They're mirror images of one another. And that's sort of what the court did. And then the question is, applied to what? Well, applied to this creature of federal law. To determine whether or not a creature of federal law fits within a New York law definition of a penalty, you ought to look to federal law. What does federal law say it is? And with respect to the Liu case, that's absolutely right, that there was an additional case that said, well, you can have a proper disgorgement remedy under equitable jurisdiction or as a matter of equity. That's not a penalty if what? You are limiting the disgorgement to the defendant's net gains, and you're limiting the disgorgement to the amounts the defendant himself or itself obtained, not when the defendant was ordered to disgorge third-party gains. Well, according to Baer's whole theory of the case, they had no net gains. They were ordered to disgorge third-party gains. That's how their whole theory of the case started. So our argument was, in a more refined way, to get into the detail of it, sure, there might be some kind of disgorgement that doesn't count as a penalty as the Supreme Court understood it. But what Liu and Kokesh make clear is that the kind of disgorgement assessment here, where you're ordered to disgorge more than your net gains and the gains of third parties, is definitely a penalty, exactly because it leaves the defendant worse off. And the last thing I'll say, by the way, you're more passionate about your losses than you are about your victories. So, it's like I have to, exercise my my adjective. But there was absolutely law well before Kokesh came out saying that a disgorgement payment that exceeds net gains that covers third-party gains is a punitive assessment. The Fifth Circuit said it in 1978, the SDNY said it in 1983, and on and on. So to the point about reasonable expectations of the insured, that was right there in the law. It wasn't a new idea. So that's right that the insurers hadn't exactly made the argument, and that's why God made a lot of lawyers, because there's a lot of different ideas and ways to prosecute a case, and if it were the case that just because a new lawyer comes in, like the new arguments the lawyer comes up with are waived, I wouldn't have a lot to do. So I hope that doesn't become a general proposition.
Well, okay, so we're well over time. Jennifer McAdam has people have to leave. Feel free. Jennifer McAdam had an interesting question. We'll give you all each 120 seconds if you can, and then we're going to call it.
Okay, real quick. So I'm assuming that both of you have probably done a lot of insurance coverage cases previously and subsequently to this case. And I'm just curious if you'd ever considered whether the term penalty is used in the exclusion in this case, whether that term should be interpreted differently depending on whether we're talking about a CGL policy or something like a wrongful acts policy. At issue here, given that the wrongful acts policy is contemplating that the policyholder would be engaged in, bad acts. So I'm just curious whether you think the term penalty should be thought of in a different way.
I don't know that I've really given that one too much thought. It's an interesting question. I don't know that CGL policies have penalty exclusions, and from my experience of looking at them. And they are here probably because you're talking about the kinds of regulatory actions that we're talking here, where you can actually have a rental penalty imposed. Maybe they do, but I wouldn't think that it necessarily should be construed differently. But I'd have to give that one some more thought. I did want to say one thing, since you've given me a chance to speak, is that in the Liu case, the court did say that if there are allegations of kind of like coordinated action at some level, that an equitable remedy of disgorgement can include third-party gains. And to me, that's a possibility that might have encompassed our case, because the allegation of the SEC was in essence that Bear Stearns was facilitating, if not actually colluding with. So I don't think it's actually clear, as you say, that under Liu, even today, the SEC couldn't get third-party gains out of a party like Bear Stearns on similar allegations. Jennifer, I'm sorry if I didn't really answer your question as well as I should, but I'd like to give it some more thought.
Yeah, I think in the CGL world, I mean, in my experience, anyway, the pressure tends not to be on whether it's like there are criminal acts exclusions. There are things that kind of look like penalty exclusions. This was not an exclusion, but there are things that do kind of refer to penalties or punishments, right? Criminal sanctions of some kind. I think the language is probably sufficiently different that there are nuances in the interpretation. But you see more in my experience. You see more litigation, and this is not my experience is not exhaustive at all, but you see more litigation about things like expected or intended exclusions, right? Because usually some kind of a penalty is going to be for a level of C-enter that can maybe be expected or intended and then some. So the insurer will more readily go to like an expected or intended exclusion than they will to the harder to prove, penalty or criminal acts exclusion. And there are other ways to get at that. I think just put more of the litigation pressure on other parts of the contract. But I don't know the answer off the top of my head. Exactly.
I mean, CGL policies do generally have punitive damages exclusions.
Right.
Just don't know whether they have penalty or fines, but maybe they do.
All right. So thank you both for coming. This was a fascinating conversation, and I think a success in terms of a format test. So we'll be doing this again. Hope you join us for future workshops too. It'd be great to see you. Thanks,
All
Tom.
right, well, thank you for
so
having
much.
us.
Bye. Thanks.